Right, we're live.
Live. All right, good afternoon. It is January the 6th, 2021. One short week before the beginning of the 2021 legislative session. It's 1 o'clock, and welcome to this House Judiciary Committee briefing. It's a virtual committee briefing, so I ask for your patience if we encounter any technological or streaming issues. Before we begin, I remind committee members the briefing is being streamed on the Maryland General Assembly's YouTube channel. Committee members will be muted throughout the briefing. If you have a question, please type question in the chat box on the right side of your Zoom window, and then I will call on delegates to ask questions. After I call your name, wait a moment until you are unmuted. Today, we're going to receive a briefing from the House, the House Judiciary Committee will receive a briefing from the Department of Juvenile Services regarding the recommendations and updates from the Juvenile Justice Reform Council. We're only going to have one panel, and it will be Mr. Secretary Sam Abed, the Secretary of the Maryland Department of Juvenile Services, and the Chair of the Reform Council. We'll also hear from Betsy Tolentino, the Department's Assistant Secretary of Community Operations. The panel will be followed by questions and answers. We certainly hope to conclude this briefing no later than 3 o'clock. It may end sooner than that, depending on the number of questions from the committee. But with that, let's go ahead and let's begin. Secretary Abed and Assistant Secretary Tolentino, whenever you're ready.
Thank you, Mr. Chairman and members of the committee. It's a pleasure to be with you today. We have been meeting for over a year on this Juvenile Justice Reform Council. And, of course, everyone knows we got interrupted by COVID-19. And it was when we were suspended for that period of time, I was concerned that we would not be able to really get a lot of work done or much of anything substantive done. But fortunately, we were able to really accelerate the pace and get through a lot of materials. And so I will accelerate my pace and get to the actual presentation. So let's go to the next slide. So we were created by legislation in the 2019 session. And we were directed, of course, to form a stakeholder group and use a data-driven approach, best practices, and to come back with recommendations to generally improve the system. And specifically, one of our mandates was to make recommendations to limit or otherwise mitigate risk factors that contribute to juvenile justice contact. So limit how kids, can make it into the system. Let's go to the next slide. One of our requirements was to select a technical assistance provider. We selected the Vera Institute of Justice. I believe it was 4 submissions that we received. And we had 12 total meetings. Only 3 of those were in person. The rest were virtual. And you'll see the report there was due last month. We are in the final drafting of that report. I believe the final draft, or hopefully what is the final draft, is out to the members of the council, and we should be submitting that shortly. Let's go to the next slide. Okay, we missed one. We go back one, was the listening sessions. I think there was one in there that we missed. No. Go forward. I think you just skipped 2 slides. There we go. There's our membership. I don't want to move too quickly past this because it was a great group of people, very diverse. I will just say that you see all the folks that are here. We had legislators, we had folks from the state's attorneys, public defenders, we had national experts and academics and every perspective I think that should be on such a committee. Next slide. We were required to have regional listening sessions, and one of the interesting things is that when the bill first passed in 2019, we thought it was a little bit compressed in terms of the time because we had to first meet and organize, then pick a technical assistance provider, and then do the listening sessions. So one of the strategies that we hatched to accelerate this was to do the listening sessions during the last legislative session. The downside was that we probably missed the opportunity for a lot of legislators to attend these listening sessions because they were in Annapolis for meetings, although we did have legislators attend meetings and listening sessions nevertheless. But it really allowed us to get all of these 16 listening sessions done. And obviously we didn't know that COVID was going to hit us, but because we had that aggressive pace, we finished all of our listening sessions in person by March. And we had 530 people that participated over those 16 sessions. And I do want to just thank the local management boards for organizing all of those listening sessions. They were very helpful. Let's go to the next slide. So after getting all of that information from our community stakeholders, we also surveyed the members of the Juvenile Justice Reform Council, received feedback from advocates, stakeholders, and others. And after getting all of that information, and also after going virtual, we came back together after a hiatus. I think we went from December of 2019 until August of 2020 without having a meeting. But these are the topics that we settled on as a group. And you can see all of these are on here. And when you get the report, you're going to see that education is not one that we have recommendations or a specific set of recommendations. There are some recommendations that are directed around education, but they're in the context of some of those other areas of the system. And so that one we were not able to get to due to time constraints. And then youth charged as adults, we got it on the last meeting, but we still had incomplete data, and you'll see in the recommendations, there's still work left to be done with that. So the rest of them we did get recommendations on, and we'll be going through those in just a moment. Let's go to the next slide. So the first recommendation that we made was to ourselves, and that was to use a race equity lens in evaluating how we do reform and any policies that we are considering as a council. And I think that that is a significant recommendation, because it means that all of our recommendations are shaped through that lens. And I also think that if we implement all of the recommendations that we made as a council, we would have a significant impact on the disproportionality we see for youth of color in the system. So I think it's worth noting that not only did we take the stance of making race equity something that we specifically and intentionally looked at, and you'll see it show up in the slides. And if you watch some of the presentations or look at the materials from the presentations, you'll see it in the data. But I think that it shaped everything that we do. And underneath a lot of these recommendations, if you ask, well, why did you recommend this or that? For a lot of them, a reason, not necessarily the only reason, but a reason is because it would, or at least we think it will, mitigate the race disparities that we see in the system. Next slide. So the first recommendation that, well, the first one that we'll cover, it's the first one that we discussed, and I think one of the last ones we actually voted through, which is minimum age of jurisdiction. Currently, Maryland does not have a statutory minimum age of jurisdiction. And what that means is someone as young as 8 or even 7 years old could be charged with an offense and formally charged with an offense and proceeded against in the courts. They could be conceivably detained or committed. And most states have a minimum age of jurisdiction in their statute. We default to the common law, which is where we get that age of 7. Most of the offenses that come from this age group are in the 10 to 12-year-old category. That's 90% of those intakes. So when we're talking about 6, 7, or 8, 7, 8, or 9-year-olds, we're not talking about very many kids, but nevertheless, it is important to ensure that we are not using the wrong system or the wrong approach for them. And then, as you see, 90% of the cases in this group are withdrawn or dismissed. So for the majority, vast majority of kids that are caught up in the system, this low age range, they are not being proceeded against formally. And so I think that's worth noting. I'll also note that, I'll also note that we have disproportionality in this group as well, disproportionately Black and disproportionately girls for the under 13 population. Next slide. So our recommendation here is to eliminate jurisdiction for children under 13 years old, with the exceptions that are listed here for youth between the ages of 10 and 12. And then what that also means is that youth under 10 would not be within the jurisdiction of the juvenile delinquency system. They would still be within the jurisdiction of social services or for behavioral health services if those things were needed, but it would be eliminated for kids under 10. And then in addition to the offenses that are listed here that were recommended as exceptions, there were also 3 other areas that were discussed and that were, I want to look at the language here that we used, but that they were, it was recommended that the legislature take a second look at those. And those were, I believe, armed robbery. Betsy, can you help me out here? Armed robbery, carjacking,
armed robbery, manslaughter, and carjacking.
So those were the ones that the council recommended a second look. And it, to be fair, I think to the conversation that we had around those 3 offenses, I think everybody recognized that they account for a minuscule number of actual intakes. And so sort of, I think there was a thought that it could go either way and probably wouldn't make much of a difference, but that's how we ended up with the recommendation, leaving those 3 out and sort of punted to you as a legislature to consider whether they should be in. So that's the recommendation for minimum age of jurisdiction. We can go to the next slide. So probation was the next subject that we looked at. Like minimum age of jurisdiction, we don't have any kind of statutory limits on what length of time kids can be put onto probation. It's left up to the court in each individual case. Most cases, and a lot of times, it's not articulated in a period of time. It's done indefinitely. And so when we looked at literature from other jurisdictions, the literature suggests that when we set goals for youth on probation, rehabilitative goals, instead of using a surveillance approach, which is typically what probation is, there are a number of requirements in the court order, and the case manager checks in and makes sure that you're doing all of those things. And so a lot of this is about changing the culture of how we operate probation and recognizing that that we should set rehabilitative goals for kids and support them in getting to those goals rather than using a system of surveillance. Let's go to the next slide. So our recommendations here, and this is sort of looking at the high level piece here, and for details I may defer to Betsy to get in there because there's a lot of language underneath some of these, but setting statutory maximum length of supervision for juvenile probation. The approach we took was a tiered approach, distinguishing between lower level and upper level offenses, but to set some guidelines within the code. Betsy, would you explore those a little bit further?
Right. So when setting the maximum length of supervision for juvenile probation, the council voted to break it out by offense type and set limits around that offense type. So if the young person is adjudicated of a crime that would be a misdemeanor if committed by an adult, the initial term of probation could not exceed 6 months. However, if there was a need to continue that supervision after a hearing, and if the court found good cause, they could add additional terms in. Those additional terms cannot exceed 3 months, And then they can be added for an overall maximum of 12 months for juvenile probation for a young person adjudicated of a misdemeanor. So initially 6 months, you can go up to 12, but between that 6 and 12, the court would look at it every 3 months. If the young person is adjudicated for an offense that would be a felony, the initial term of probation is not to exceed 12 months. Again, if the court finds good cause, they can extend those periods of probation in the same 3-month terms up to 24 months. Realizing that even after 24 months, there may be a need to continue supervision, the court may extend community supervision up to 36 months if there is clear and convincing evidence that extending supervision is in the best interest of the child. And then lastly, if the child is adjudicated of an offense that would be a crime that carries a penalty of life imprisonment, if committed by an adult, the term of community supervision can continue until the age that jurisdiction is terminated, which in Maryland can be up to 21. Thank you, Mr. Secretary.
Thank you. So all of that will be detailed in the report, and it is in the report. So if we have questions, we can certainly go back to that. The next area on probation recommendations was to prohibit the use of detention or commitment. So this is really looking at two things here, but I think we have one that corresponds due to a technical probation violation.
Mr. Secretary, I am sorry to say this, but we have to stop. We're having problems with the live feed that is supposed to be going out to people. This has got to be a public meeting. We're having difficulty at the moment ensuring that people can find the link, at least at this point. There is a link available for people to click, and I've clicked it a couple times and it's working, but it doesn't appear to be coming up on the General Assembly's website. So we're going to stop for a second here and just and Mr. Secretary, I hate to say this, but we may have to ask you to start again. So give us one moment. Dylan's going to work on it, and we'll be right back here just in one moment. So please hang on one. Everybody stay on the Zoom if you can. Thanks. Thanks. I'm doing it right now. All right, here's where we are. We were live streaming. We still are live streaming for that matter. We apologize for the problems here. Mr. Secretary, I do not need you to start from the beginning. You can go back to or if you're on the place where you were, that's going to be fine. What people should be aware, the issue now is more the link to view the live broadcast is kind of the issue here. And that link is on the committee's page, the committee's YouTube page or not YouTube page. It's just on the Maryland General Assembly's page. The Judiciary Committee has its own place where you can go and watch the hearings. And this is what we're going to be doing during the legislative session. So I suppose it is natural that we're going to have a little bit of growing pains here as we go along. In the chat, I believe that Dylan posted the specific place where people can go and watch the or where there's a link there. You should use that if people in your districts want to watch what we're doing here. But with that, the link is working so that people can watch us in their homes. Mr. Secretary, let's go ahead and continue with your presentation. And I do apologize for the challenges here today.
I totally understand. I appreciate it, Mr. Chairman. And I believe we were on the prohibition of detention or commitment for technical violations of probation. So the actual recommendation reads that we would prohibit use of detention or commitment for technical violations as currently defined in 6-101 of the Correctional Services article. So there are some exceptions to that, I believe, around violation of protective orders and that sort of thing. But generally speaking, violations would not be triggering detention or commitment. The next one is to establish a statutory process to return certain petitions forwarded to the court back to DJS for assessment services and supervision. This is the one we call return to intake. And that's when a state's attorney or we may have forwarded a case, but after further investigation, the state's attorney and working with a defender may decide that this needs to go back to the department's intake so that it can be diverted. And sometimes that happens, and we want to just make sure that there's a process for which that can go forward, and then we can put them into that informal supervision and still get them the services. The next recommendation here is to establish a work group through a bill to study and inventory evidence-based and promising practices. And if you're familiar with the Washington State model, they have a model where they actually evaluate all of the different. So it would be an inventory of all of the programs that we use, and then an evaluation of those programs. That information gets posted in Washington State. And then I think another component of this is about giving those sort of promising practices, the ones that are coming up organically in the community, the tools that they need to become evidence-based practices through collecting data and the evaluation process that this would put in place. Let's go to the next slide. So this one is getting now into detention utilization. We just note here that the initial detention decision is made by an intake worker for these cases, and then gets reviewed by the court the next business day. And I think the big key here are the data pieces. 40% of our predisposition, those are kids that are waiting for trial. 40% of that detention population are there for misdemeanor offenses. And the race disparity here is at its worst. 78% of admissions are Black youth, and the general population is somewhere around 32%. So it is a significant disparity at this decision point. Let's go to the next slide. These are our recommendations on detention. The first one here, requiring courts to consider the findings of validated risk assessment. We have a validated risk assessment that we use for detention, and many courts do follow that. This is not a huge change in practice, but it would mandate it for all courts. Require courts to review child's detention status at least every 14 days. We don't want anyone losing track of kids or letting them linger in detention. Requiring DJS to develop and submit a community release plan within 10 days of a decision to detain a child. And this is around, I think the idea here is that if we are going to commit to trying to keep kids in their communities rather than in detention, we need to overcome the obstacles that kids would have that would otherwise be fine in the community. And what we say here is that sometimes you have situations where the risk tool is saying we should release this person, but we have other situations. There may not be someone, a parent available to take custody of them, or some other obstacle that needs to be overcome. And when we have those situations, it's incumbent on us to put a plan together and at least bring that to the court so that they have an option other than detention for a kid that we know shouldn't be in detention by our risk tool. The next recommendation here is to prohibit pre-adjudication detention for an offense that would be a misdemeanor if committed by an adult. So not to detain misdemeanor youth with the exception of handgun offenses. Sorry, it looks like there's a question, Mr. Chairman. You want me to pause and answer the question, or?
No, I'd like you to keep going, and then we'll do questions at the end.
Okay. So we put the exception here for handgun offenses. I think that's, there was a lot of discussion about this. That's usually the sort of the sticky part of accepting misdemeanors for detention. And this is where we landed. The last recommendation here is for DJS to report to the General Assembly on our programming and policies. It's actually a larger, it's a pretty big list of things that is required of us to report to the General Assembly. But it's about the services that we're providing and making sure that we're tracking the things like shelter beds that we would need to have as options for kids that would otherwise land in detention inappropriately. So let's go to the next slide. So the next area here is on out-of-home committed treatment programs. And one of the things that our technical assistance providers highlighted here were that other states had made a lot of efforts to keep kids closer to home. And in New York, they have a program called, or an intervention called Close to Home. And we looked at that, and that's certainly one of the things that came up in our discussion. Here again, we see a disproportionate number of Black youth represented in the committed phase of the system, overwhelmingly Black in the committed programs. And half of our kids in commitment are there for misdemeanors. So I think that gives us a lot of area for improvement. Let's go to the next slide. So these are the recommendations that we had for out-of-home, there we go, out-of-home committed placements. So again, prohibiting commitments to the department for misdemeanors or for technical violations with an exception for a second firearm offense. The only firearms offenses I believe that were misdemeanors were those possessions or constructive possessions. The other firearm offenses are felony offenses. The next one here, plan to ensure every region has access to services, both community and residential services in their.
Did you drink my beer that was in there?
No beer in there.
Sorry.
Open the door.
Hearing a little bit of feedback.
Delegate Conaway, if you'd go on mute, please. Thank you. Secretary Abed.
Thank you. So this one received a lot of attention, but really the way I look at it is this is just telling us, hey, DJS, you've got a requirement in the existing law to have services for kids in every region, and you should come up with a plan.
That was crazy.
And we will do that. The next one is comprehensive educational program in every DJS facility. Again, this is already a requirement, but I think a statement that education is important, even though we didn't get to that topic specifically. And then the last one here, ensure vocational education and on-the-job training is available at every DJS facility and contracted program. And so I think that's pretty self-explanatory. Let's go to the next slide. All right, diversion. So I think the focus of our work here was to look at ways that we could expand our use of diversion. When we look at the data that we have for kids that are diverted, they are successful. As you can see, 90% of youth that complete pre-court supervision do not get re-adjudicated or reconvicted within a year. 80% are successful who take part in that pre-court supervision. And so we want to take advantage of more of these cases, even though we resolve or informal a lot of cases already. As you saw on the earlier slides, still a large portion of our detention population and half of our committed population are misdemeanants. And so if we can successfully divert kids at the front end, then we can reduce those numbers significantly. Let's go to the next slide. So I'm going to let Betsy walk through these recommendations, mostly because I need to take a little bit of a break.
All right, Mr. Secretary. So our recommendations related to diversion, starting out, the council wanted to recommend that we used an informal adjustment or pre-court supervision for all first-time referrals for a misdemeanor or non-violent felony. Again, we would accept out the firearm offenses. The next is that the council recommended that we eliminate the requirement of victim consent for an informal adjustment to proceed. This does not eliminate the requirement that the department notify the victim of the conditions of pre-court supervision or an informal adjustment. The next is to eliminate the requirement that DJS forward all complaints alleging nonviolent felonies to the state's attorney for review and approval in order to be able to proceed with an informal adjustment. Next slide. The next is to eliminate the requirement that certain citations must be forwarded to the state's attorney, allow the use of citations for misdemeanor offenses, and allow for police citations to be resolved through police diversion or through a complaint to DJS. The next recommendation was to narrow the definition of delinquent act to mirror the language that's already contained in COMAR in the education section, and that narrowing that definition would sort of identify that delinquent acts do not include conduct which has traditionally been treated as a matter of school discipline. And lastly, the Governor's Office of Crime Prevention, Youth, and Victim Services should develop a model law enforcement diversion program for the state. Next slide.
All right, I'll take it back from you. Thank you, Betsy. All right, youth charged as adults. This was the last topic that we covered in our meetings. And as I mentioned at the beginning, this is one that we did not complete. And one of the biggest challenges was the data. And as we went through, I mean, this was a highly ranked area. People wanted to talk about this particular area, and I had to keep moving it back on the agenda each meeting because we did not have all the data from the jurisdictions. And the challenge here is that we have some of the data at the Department of Juvenile Services because kids get sent back to us or they get requested for transfer, and we're involved in those cases. So we know about those, but there are cases of youth charged as adults that are not eligible to come back. We don't have the full count, so we don't know the whole universe. And to get the whole universe, we have to go to all of the local jails. And that was very challenging. We got most of the jurisdictions, but we were unable in the end to get Montgomery County and Prince George's County. So we missed two big jurisdictions in getting all of that data. So that was a frustrating part. And so when we go to looking at the recommendations, let me just to touch on these some of these things. We have a long wait time. This is something that has always been around for youth charged as adults. Those are kids that we hold. The majority of these kids do get transferred back. 75% are transferred back to juvenile court of the ones that we can account for. And again, here we see large disproportionate treatment for youth of color in the system. So a large area of disparity where youth of color are charged as adults at a higher rate. Let's go to the next slide. So this is sort of the punt that we had to make at the end of the council in our last meeting. And the first recommendation here is just to let's fix the data issues that we have. We've been, I think this issue has come up so many times over the years, and this is a common refrain that we have this data issue. The good news is we came closer to getting a complete set of data than we ever have. All but 2 jurisdictions is the furthest we've gotten. But I think that if we could have, if we're going to have any success in making reforms happen, we can't put that kind of effort in just to get a snapshot. We need to have routine collection of this data. And so this recommendation is about trying to create that routine collection of data and reporting so that not only can we see what the picture is and make an informed recommendation, but also we can track the progress of any interventions that we put in place. And so the next recommendation here is to extend the council because we weren't able to finish this. We were not able to finish the other areas. And those 7 areas that we talked about at the beginning, at the very beginning, were already themselves a bit of a compromise because of the compressed time due to COVID. So I do think that there is still work to be done, but I am very proud of the work that we did accomplish. Let's go to the next slide. Okay, I thought it was the last one, but I needed to be sure. This website here has a tremendous amount of information on it. It does have, I don't know if we have the final report on the website yet, Betsy, is it up there?
The final report will be posted on the 13th or 15th, between the 13th and 15th.
Okay.
On the website.
All right. We also have all of the video if you ever want to go and watch the meetings that we had. Even the in-person meetings are archived, as well as all of our virtual meetings. But what I found really helpful is also to look at the meeting minutes. We have sort of bare bones meeting minutes, but they clue you in on the areas that we covered, so you don't have to spend a lot of time watching video if you don't want to see it. And then, of course, all of the research that Vera provided for our council is there, and I think that there's a lot of great information that you can find and certainly enrich what we have stripped down into the very bare components in this presentation. And with that, I'm happy to take any questions.
All right, there is a question first from Delegate McComas. If other members of the committee have questions, please indicate in the chat. Thank you. Delegate McComas.
Thank you, Mr. Chair, very much. I just was wondering, because there's such a high percentage of Black children, going into pre-detention or going into commitment, through the different steps, I was wondering if, because you all are very, very familiar with the issue, is there something in their background, family life, or an issue of poverty, or an issue of what do I want to say, like a systemic racism? In other words, is there something there that's causing these children that can be identified to going into the system as it's currently set up? I'm just kind of curious about that.
I mean, I think there's probably all of the above is that and more. There are so many contributors to why we have the disparities. I think the way I sort of break it down, the two main categories, you've got sort of your individual decision maker bias types of disparity, which certainly can happen, and we try to hedge against those with those decision tools, objective decision tools. So, you know, you could have a person that's, you know, whether it's a police officer, an intake worker, anybody can have bias. Everybody has bias, but it can creep into their decision making. And then, yes, we do have structural racism. I do think that there are structures in place, both in our procedures, in the departmental procedures and the way that we operate, and we're trying to identify those, and we actually have a process for trying to identify those. And we also have those types of structures that I think that exist in statutes that that create burdens for youth of color. But there are just so many different things that push young people into the systems: educational disparities, health disparities, financial disparities. There can be many other things. And I think the challenge for us is not to try and look at and solve all of those other sort of societal issues, but to look at what we can do in our system and understand that people are coming to us from different points, and we need to take them from wherever point they are and sort of level the playing field for them when they get into the juvenile justice system.
Just a quick follow-up. Children that have been through the juvenile justice system and not by an informal way, do they have a higher likelihood of then getting involved in adult criminal justice system later on? Is a higher percentage?
I don't know that we have literature to show that. I know that that is the sort of what most people believe. But, you know, we don't have studies to see, you know, how many kids went from, you know, that ever touched the juvenile system, that, you know, did they ever land in the adult criminal justice system? My sense is that's not what's happening. I think that a lot of young people, particularly in our system, when you see how many kids are there for misdemeanor offenses, these are things that are I think, very closely associated with their developmental stage. And as they get older and they mature, they stop acting in that way. And I think that they become productive citizens. But I don't have any definitive studies that I could point to.
Thank you.
Thank you. We're going to go to Delegate Davis, Delegate Deborah Davis next, and then Delegate Crutchfield. Delegate Davis.
Thank you, Mr. Chair. Secretary Abed, thank you for all of your hard work. And I've just got a couple of notes and a question. The idea that you're going to make the recommendation that you look at your policies through a racial equity lens, I commend you on that. It is definitely necessary because I can tell, as we all can tell from the statistics, from the disparities and how we're moving forward with juvenile justice, that, you know, we're sending young Black and brown people, you know, into the system at an alarming rate. So my question is, what's next? These are recommendations. And I'd like to also add that we circle back in a timely manner, that we're not revisiting this in 2 years, or that we set up a recommendation that we come back in 6 months to see whether, if we put these recommendations into effect, whether they actually make a difference. Because I don't think our citizens can wait another 2 years or 3 years to see what the results are. Thank you.
Yeah, thank you for those remarks, Delegate Davis. I think for some of these recommendations, they're directed at the department. And so there are things we're already working on and either have implemented or will be implementing. And one of the recommendations that we have is a report to the General Assembly. So we do have that in our, as a council recommendation to report how we're doing in terms of the implementation of much of this. And we also have our data resource guide. And that's the way that we track, you know, the implementation of you know, our initiatives, and we publish that every year. But I think, yeah, there are things that the department it's directed to the department to do, and then there are things that need to come in as legislation. And when you look at some of these full recommendations, I know I've summarized them here, but some of them they look like bills, and I think that's something that needs to be considered. And Betsy, I know you've got some more information on that.
Yeah, so there is a bill being drafted that would place the recommendations in legislation for your review in both the House and the Senate.
All right, Delegate Crutchfield.
Thank you very much, Mr. Chair. And I greatly appreciate Secretary Abid and also Assistant Secretary, because you guys have also provided weekly a conversation between the elected officials and DJS to understand what's going on regarding COVID. So I greatly appreciate that. That's been very helpful. And I also want to just commend you again for at least leading this effort and also coming up with these recommendations. I was going to ask about some of the equity issues as well, and Delegate Davis has already done that. But I did want to just understand a little bit about, in the recommendation for race equity lenses, you talk a little bit about vetting it. And have you thought specifically how you're going to actually use and create a plan to do just that?
So yeah, let me answer that in two phases. Okay. One, in terms of vetting, when we talk about a race equity lens, and I mentioned that we're looking at our procedures and our policies that way. There is actually a structured evaluation tool, and it's in our data resource guide, and it is a sort of qualitative analysis. We go step by step through a policy and identify through our data, is there a disparity there? If there is, what are we proposing, and how will that impact that disparity? Is it going to mitigate the disparity, or is it going to exacerbate it? And if it's going to exacerbate it, can we get to that policy, the goals of that policy, a different way that don't exacerbate or that do mitigate the disparities? So it is a structured way of looking at policy so that we can evaluate what we're doing and what our practices are. In terms of these recommendations, as I mentioned at the beginning, that first recommendation was not actually a recommendation for the General Assembly to do something. It was a recommendation to our council, to ourselves, that we will identify the race disparities. And so you see, we summarized it, but in the detailed presentations, you'd see race data on all of these topics. And that underguided or undergirded all of our conversations, or a lot of our conversations about why we should be doing this or that. So when we looked at the minimum age of jurisdiction, for instance, that first recommendation, we saw that there was a disparate impact. There were more youth of color at that low age group that were there, again, primarily for misdemeanors. And so if we can block them from coming in altogether, which is what that recommendation does for 7, 8, 9 and year olds, then we're mitigating that disparity there. And so as you go through these recommendations, they sort of underpin what we're recommending. Does that make sense?
Okay. I have one other question for you that's a little bit off the topic, and that's dealing really with the intake process. I mean, I understand that you have case managers who provide that first contact with the youth. And it seems like there may be, I don't know if there is not enough bonding, or if the case managers don't have the skills, but I would think that part of what you also would provide for your case managers is some training regarding just adolescents, brains, just involving how to really bond and to pull the children in so that you can get past some of the issues that you have. Just simply providing some kind of basis to your case managers, I think would be very helpful, because I haven't heard that at all. I've heard that case managers, they may have degrees, they may have some training, but I know there's a lot more training out there that could really equip them to handle and to guide the children through processes and diversion, and to also make it clear as to what diversionary programs those children really need to go into. So I wanted to just get a little bit of thoughts from you about how you can further engage your case managers, or just develop more around that, so that the intake process is smoother and you're actually very, that you can get some effective outcomes from that.
Yeah, I think, Delegate, you're absolutely right to be putting your finger on intake, because that is a critical decision point. And our staff act as magistrates, essentially, in that process, whether to forward a case formally, whether to detain a youth that night or that at that moment. And those are huge decisions to be making. And that is where our resources should be. And so I'm gonna let Assistant Secretary Tolentino, because this is her area, and we are doing a lot of work in this area. But what we're really looking at, and a lot of the conversations that we had on the council, is we've got to change the culture of our case managers away from that surveillance culture of, we're going to make sure that you've done this, and this, and to a culture of supporting youth in their success. And that's how we have to frame the success of our staff. Their success is tied to the success of our kids. And so that if we can somehow do that, I think that will help move the culture. But I'm going to let Betsy talk a little bit more about what she's doing to further that.
Yes, so we've been making a lot of reforms and progress at that intake level, really sort of creating a system that can provide a young person whatever they need at that first sort of stop at intake, whether it's a service or support. So we've had to shift our system around a little bit to allow for that. You're right, we do need to do more training for our staff at that front door and really focus on that positive youth development. And we are working on formulating training curriculum that we can use for really our whole staff, and the principles of adolescent brain development and positive youth development. Additionally, we're working with ROCA, which is a program in Baltimore City. They sort of started out in Massachusetts, but they have an Impact Institute. And ROCA uses a model to work with young people that's really based in cognitive behavioral therapy, really trying to take the opportunity for every contact to be a chance to work with that young person to improve behavior change and really get some better outcomes. So we have a small group of case managers right now, including myself, receiving that training. And our goal is then to be able to present that to the rest of the agency. Their model really meets young people where they're at, really works with young people on moderating their behavior and making different choices. And I think that would be a really great intervention at the very front door of the system.
And I'm just going to add one other thing, Delegate Crutchfield, to that response, and that is that, we have to change the way that we evaluate. I mentioned that our staff, our primary metric is recidivism, which is an evaluation of failure. And Betsy mentioned positive youth outcomes or positive youth development. And those are the kinds of outcome measures that we need to develop. And we are now part of the longitudinal data system. This is the education longitudinal data system. And we have made requests, and they have been approved by the board to bring our data into that system and start looking at how kids are doing in their other outcomes. We only look at recidivism. And so that's such an unforgiving metric, because if we have a young person that recidivates in the first 3 months, they may do a new misdemeanor offense, right? Well, they're now a recidivist forever in our data. Well, after they recidivate, if they do just fine, they're still a failure in our data, in that data point, even if they go on and live a good life. And so we want to go and see, well, how are these kids doing later on in life? Did they finish high school? We can find that data. Did they get a job? Do they have a stable home? Are they doing things, achieving things academically? Because if they are, those are excellent outcomes. That's the kind of thing that we want to see. And because we do know that young people do mature and they change. we shouldn't assume that once they've, been in our system that they're always going to be involved in the criminal justice system. I do believe that the majority are not. And once we start getting that data, we can start showing that picture.
Thank you very much.
Thank you, Delegate Crutchfield. We have questions now from Delegates Conaway and Cardin. Delegate Conaway.
Thank you, Mr. Chairman. Thank you, members, and thank you, friends, for texting me about happy birthday. Anyway, on page 12 of the briefing document, what is the racial breakdown of the percentage of the 40% that are admitted? Secretary, please.
Sure, I'm going to have to ask. Well, let me go back to page 12 here. I've got a copy of it. So you're looking at the detention utilization slide. Misdemeanor offenses accounted for 40% of predisposition detention.
Yes, but then it goes, yes, and then under that it says that talks about the Black youth.
Yes, so that is the racial breakdown. 78% were Black.
And then the 22% are other.
Well, they would be white or other. I think that our data is a little bit suspect when we get into other categories. We don't have the ability to distinguish between folks that are mixed race or anything, but if they identify as Black and we can identify Hispanic or Latino, and beyond that, we don't have an ability to really distinguish in our data.
Okay, so at the bottom line, we're saying 78% of the 40% are Black youth. Is that correct?
Well, 78% of the pre-detention, predisposition detention admissions. So they're two different things. They're not 40% and 78% of 40. So 78% of pre-detention admissions. So that's of the whole entire predisposition detention population, 78% is Black. 40% of that population, not of the 78%, 40% of the entire detention, pre-detention population are also misdemeanants. So they're not, it's not, they're looking at the same population in two different lenses. One is looking at felony versus misdemeanor. The other one's looking at race.
Yes, I understand. Okay, thank you.
You're welcome.
I will accept responsibility for not recognizing that Monday was Delegate Conaway's birthday. So as not to further exacerbate my oversight, I do wish to wish Delegate Conaway a happy birthday from Monday and Delegate Bartlett a very happy birthday today. With that, Delegate Cardin with a question.
Thank you, Mr. Chairman. Happy birthday to everybody. Thank you, Mr. Secretary. Thank you, Madam Assistant Secretary, for all your work. This is really tangential, but I want to just throw it out there as something to think about. How do you work with and react to the initial interaction of juveniles in the system? And the reason I'm asking the question is because I actually had a case where I represented one of 4 young Black boys, 13, 14 years old, who were charged with crimes. They were sat on a curb. They were handcuffed. They sat there for 45 minutes. They didn't alert their parents, even though they were right outside their house. Then they were taken into the station. They were questioned for over an hour without any consent or information to the parents. And then they were charged with crimes. And it happened to have been against a young white boy. In the end, everything, I'm not going to talk about details of the case, but in the end, everything I think worked out. The point is, I'm wondering how you guys are working with police, maybe prosecutors, to make sure that there are policies in place that are working in conjunction with what you're trying to accomplish. And I'll stop there.
So yeah, I think Betsy consents. I'm gonna let her respond because she is engaged with so many police departments, Baltimore City and Baltimore County, but we do work directly with police departments, particularly around trying to engage them on use of police diversion, because they do have the authority to divert. But all of what you described there, I think we're interactions with the police, we would come in later after the police have, gone through those steps. Then they would bring them, if they were requesting detention, they would bring them to a detention center, or they would just simply give us paper documents in most jurisdictions if they were not requesting detention. Betsy, do you want to add to the sort of the specific stuff we're doing with the police and embedding staff and so forth?
Yeah, so in a few jurisdictions, we actually have staff members that we have been able to embed into the police precincts. In Baltimore City, we have one staff member who's worked in the Baltimore City Watch Center for a very long time. We're expanding that effort to place case managers into the Baltimore City intelligence centers so that we can really strengthen that communication. And about 2 years ago, we added a case manager in Baltimore County to work directly with law enforcement in Baltimore County and really help with that police diversion, really processing cases and doing records checks and making sure that we're there to support police diversion in any way we can. Pretty much that is our message to law enforcement around the state. However you need us to help support police diversion, we're here to do that. And the secretary indicated sort of the two different pathways you can come into the juvenile justice system. One is if law enforcement brings you to a detention center and says, I believe there's a public safety risk and we should detain this young person overnight until the court can review their case. And the other is through a paper charge. If we have a young person come into detention, then we do our detention risk assessment. We call the parents, we talk to the family, we talk to anyone we can get a hold of. Oftentimes we talk with prosecutors, depending on the severity of the case, we talk with law enforcement, and we sort of make our decision as well as notifying everyone about what's going on. If we have the paper charge, we schedule an intake conference at some point over the next 25 days, where we have the family come in, we sit down, we do all the assessments, we talk to the family about what's going on, we talk to the young person, we look at what we can find out through those assessments, and then we make a decision on the best course for that case, whether we just resolve it, we do a pre-court diversion, or we send it to the prosecutor for formal action.
Thank you very much. I know this is really tangential, but I think that this initial interaction with the legal system is so important, especially when you're dealing with you guys are the experts in dealing with people who are young. And I'm wondering, I mean, there's Baltimore City, for example, has a 128-page book on policies and how to interact. Whereas in Baltimore County, I think that Baltimore City's is like 3 pages of it deals with youth. 3 pages of a 128-page book deals with how you interact with youth at an initial involvement. And it's just very concerning that maybe this is something that you guys ought to think about, because you might be able to reduce your load of work on the back end if you're improving it on the front end. It's just a thought.
Well, we definitely agree with the thought in terms of we want to help the back end from the front end, and to the extent that we can work with the police, and we do, that's certainly helpful. And I don't know that we'll be able to sort of intervene in the interactions that early between a citizen and police, but if there's anything that we can think of, we certainly would be interested in collaborating with them.
All right. Seeing no other question from the committee. If there are further ones, you can put it in the chat. I have a question, and I want to talk about very briefly what happened on Christmas Eve at the Hickey facility. And it sounds like it was one of I guess it's a contractor who works within the Hickey facility, and there was, I know that there were people charged with, I think, with the rioting, so I'm going to call it that, but there was a very large disturbance within the facility. And Mr. Secretary, I'd like you to address that. And I'm particularly concerned that it sounds like adults, or at least from the Baltimore Sun article, it left me with the belief that there were adults who were working at the facility who were somehow involved in that as well. Could you, if I'm wrong about that, that's fine. And if I misread the Sun article, that's fine. But if you could talk a little bit more about what happened there and DJS's response to that, I'd appreciate it.
So yeah, let me just say this and put it in this terms first, that state police is the lead investigators on that situation, and their investigation is ongoing. And our stance is when state police is investigating a criminal offense, we have to wait for their investigation to conclude before we can go and interview kids or interview other people. And so I believe that will, conclude, fairly soon. In terms of, the incident, as you mentioned, and I think the details in the Baltimore Sun were demonstrated that the kids in the facility did gain control of the facility. They did property damage within the facility, and the staff were not able to wrest control back, and they had to call the police. This program itself is not our program. It is a privately operated program that is housed there on the Hickey campus. So it's within the secure perimeter of the campus, but it is not part of the detention center. It's in a separate building, and it's operated, as I said, by a private provider, and they're licensed by the health department. And so we're going to investigate as an administrative investigation, so separate from the criminal investigation for the actions of the kids. And I am not aware, Mr. Chairman, about staff being involved as co-conspirators or somehow being, I'm not familiar with that, and I haven't been given the police investigation. But we'll be looking at things like their staffing levels, how they responded, and whether they were, following all of the guidelines that we set out for our programs, the private programs that we monitor. And we monitor these a little bit differently. Again, we're not the licensing agency, so we are, it's a little bit different. But we'll be working with the health department. They'll be looking at it as well, independent from ours, for those same sorts of administrative things.
Mr. Secretary, and I believe I misread the Sun article. It looks like that the people who were adults who were involved were people who were part of the program who were over 18.
Yes. I'm sorry. They were over 18.
Okay, and I apologize to the committee, and so that was inaccurate. So I'm happy to hear that there is an investigation going on, and that we're going to get to the bottom of what happened with that. All right. Are there further questions from the committee? I didn't see any further questions from the committee. With that, a couple of things, but first, thank you very much, Secretary Abed, very much. Thank you, Assistant Secretary Tolentino, for your speaking today and for the work of the JJRC. I've been pleased to be part of the JJRC and have participated in the meetings that we've had. I'm glad that we've been able to make progress during the pandemic. Delegates Pippi and Delegate Jackson from the Appropriations Committee were also involved on the House side, and I know that they were particularly involved as well. So we do thank you all very much. Very briefly before we close, apparently there's another birthday that I forgot in the last couple of days, and that is that of Delegate Mike Griffith, whose birthday was on January 1st. Okay, I think I got all of them now, but happy birthday to Delegate Griffith as well, along with Delegates Conway and Bartlett, and now I'm thoroughly in all kinds of trouble. With that concludes the briefing from the House Judiciary Committee. The next time that we are going to be together, it will be virtually at our first committee hearing on the 14th, next Thursday, when we will begin hearing bills in the first days of session. Certainly look forward to seeing everyone there. And I will mention that we have that set place on the MGA's website where people will be able to watch the Judiciary Committee's hearings as they happen. So with that, thank you all very much. Thank you again, Secretary, Assistant Secretary, and we are adjourned.